Good afternoon and welcome to what I hope will be a series of video webcasts that we at King's Chambers are going to place on our YouTube channel for the planning department, where occasional issues arise from cases that we've been involved in and which we think may be of some interest to our clients, colleagues and the wider public. So I call this little webcast A Tale of Two Cities, although it involves neither cities and isn't much of a tale. The two locations that it involve two residential appeals, one of which is in the outskirts of Northampton, the other of which is on the outskirts of Braintree. Both involve peripheral greenfield sites. Both involve development between the gap between the main urban area and a smaller settlement to the south. Both are around about the same sort of size. One's 250 dwellings, one's 300 dwellings. Both are put forward in the context of an immediate adjacent large urban area which has a significant housing need. Both have very, very different outcomes. So, the first of the cases involves a site at Grange Park. It's a decision of Inspector Woolcock, dated the 7th of December of last year. As I said, it proposed up to 300 dwellings, outline consent save for access, as well as land for a new school. It was refused by South Northamptonshire District Council on the 19th of February of 2020, despite a very clear recommendation for approval and despite the support of the local highway authority. It's a greenfield site. It lies immediately to the south of the Northampton conurbation, but it lies within the adjacent district of South Northamptonshire, as I said. It's close to a large country park. It's also very close to major employment, as well as close to a recently constructed in the last 30 years estate called Grange Park, which is about 1,000 dwellings with a local centre. And despite it being a greenfield site, there was no technical objection to its development. So, for example, in relation to ecology, ground conditions, noise, despite the proximity of the adjacent M1, and no landscape objection. There was no character and appearance objection from the local authority. And indeed there was an acceptance that if developed the site would form a logical extension to the urban form. The issue was whether it was sufficiently accessible to services and facilities. And that wasn't just an issue in its own right, it was an issue as the policy context and the policy consequences. So basically the site was separated from the estate to the north by a short width of woodland called Alamein Wood, through which it was proposed to construct a pedestrian access and cycleway with some lighting. And the distance to the local centre will be about 1 kilometre away, and the distance to the nearest existing bus stop will be about 15 minutes away, walking north from the site through the woodland straight to the bus stop. There was a proposal to bring in a community bus service into the site, which will be funded for a period of 10 years. One of these forms of buses which has a route through, but where one can call upon it, book it in advance, and they plan the route. It's a more sophisticated approach with regard to a bus than might ordinarily be the case of the standard scheduled service. And there was ready access northwards, but it was just a bit of a walk. And it was accepted that most of the employment in the local centre was within a cycle distance. The complexity was this, that Northampton has a joint core strategy with adjacent areas which identified what's called the Northampton related development area, so not just Northampton but areas around it. And there was a calculation for what the 5-year land supply was for that, and that was 2.75 year supply, so a quite significant deficit in relation to that. And I just note in passing that Northampton is one of the few conurbations, I think the only conurbation, that's controlled by the Conservatives at the moment, which falls within the uplifted 35% in the new standardised methodology. It's a location to which development should be directed and for which there is a significant current deficit. Within South Northampton's district, there is an 8.26 year supply. So if the development was thought to be Northampton related development, then it would be in a location to which the tilted balance would be engaged, because it would be a 2.75 year supply. If it wasn't NRDA, Northampton related development, it would be assessed against an 8.26 year supply. And the There's a variety of different policies, both in the recently adopted local plan, policy SS1, and also the joint core strategy, that tells you what Northampton related development is. It's a sophisticated approach to get over the fact that the boundary of Northampton is a very tight boundary in this location, and effectively you have to identify meeting certain objectives before you're treated as Northampton related development, even if you lie in one of the adjacent districts. One of those issues was whether there was a maximisation of non-car related modes of travel. So if the conclusion was that the development maximised non-car related modes of travel and shortened travel distances, then it would conform to the local plan policy, would conform to the joint core strategy policy, would be Northampton related development subject to the other objectives which were found to be met. But if it didn't, it will be found to be South Northampton development, South Northamptonshire related development, and therefore it would be tested against an 8.26 year supply. So there's an extra importance to the issue of sustainable modes of transport. Well, the inspector undertook an exceptionally detailed critique of sustainable modes of transport. Now, as I think I mentioned before, this was a site which was recommended for approval by officers. It was also a site that the local highway authority had assessed as to whether it was accessible enough. Not only did they provide a view that they thought it was, but they also had an officer turn up at the virtual inquiry who said so and gave reasons for that. So the officer indicated that it was sustainable enough. Local authority officers who'd first recommended for approval plainly obviously thought the same thing as well. Well, the inspector, having taken a very detailed critique of the various standards and the distances to walk, the quality of the bus service that was proposed to be provided, concluded that it wasn't sustainable enough. For example, the distance to the local centre was over a kilometre, the distance to the nearest existing bus stop was about a 15-minute walk, and he had some detrimental observations to make with regards to the proposed bus stop. So he concluded therefore it didn't meet that part of the objectives of the core strategy, and therefore was not NRDA, Northampton related development, and therefore the tilted balance wasn't engaged. There was a 5-year land supply and the appeal was dismissed. Well, contrast that with a case in Braintree which was decided within a matter of a few days of that decision by Mr. Inspector Jones. So it was a decision on the 14th of December of 2020, a scheme for outline planning permission for up to 250 dwellings on the southeast of the Braintree conurbation. Essentially an expansion immediately adjacent to a small industrial estate which was itself not part of the defined settlement boundary of the town of Braintree, but immediately to the south of the appeal site in that case was a small village called Tye Green. Tye Green was part of an area called Cressing, and there has been a neighbourhood plan that had been very recently adopted which identified the location of the appeal site in this appeal as forming an important gap, and there's a policy construct with regard to how one should protect development within that gap. Well, it was refused by Braintree District Council on the 5th of December of 2019 on a number of grounds, but particularly the effect on the character and appearance of the area because it was beyond the settlement and contrary to countryside policy, and also in conflict with the gap policy in the then emerging but now adopted made neighbourhood plan. So you may be aware that planning in Braintree has not exactly been straightforward over the years. It came together with other Essex authorities to try and promote a series of garden villages and came a bit unstuck, and it's no surprise therefore that at the time of this appeal being determined there was no 5-year land supply. It was actually agreed that it lay somewhere between 3.7 and 4.5 years supply. So it was over 3 years but less than 5 years, and it was agreed that the deficit was a substantial deficit or significant deficit. But if it had been within the neighbourhood plan area, and if the neighbourhood plan or if the issues in the neighbourhood plan had met the test of paragraph 14 of NPPF, then the tilted balance, which is engaged by the fact that there isn't a 5-year land supply, could potentially be disengaged because one's developing within a neighbourhood plan area for which there are allocations, and there were allocations in this case, and for which there is more than a 3-year supply in terms of the district as a whole, providing that that had also assessed the requirement and that requirement has been examined. And that's important, I'll come back to that. So it was accepted that because of the date of the local plan, the adopted local plan, that the countryside policies were out of date, and also because of the application of the tilted balance. The inspector considered there was some harm to character and appearance, but did consider that there would be a maintenance of the separation between the conurbation of Braintree and to the south the village of Tye Green, that there would be a limited effect on the gap, there would be a separation maintained. There was also a peripheral issue with regard to odour and noise from the adjacent employment and waste facilities within the industrial area, but the inspector found that that wasn't a concern. So the inspector considered that permission should otherwise be granted, tilted balance engaged, and then turned to the issue of paragraph 14 of MPPF and concluded that in the particular circumstances of this case that there hadn't been a requirement that had been set in accordance with the toolkit for neighbourhood plans, nor had it been examined. It had been noted by the neighbourhood plan examiner, but no more than that. So therefore the terms of paragraph 14C of MPPF hadn't been met. So in the circumstances, the inspector allowed the appeal. If one looks on a map at these two sites, one will see that they are very similarly located with respect to both the conurbation and also the small settlements to the south. What one will see is really 3 points to draw from the contrast between the two appeals. The first is the concentration upon non-car modes of travel. They both have a similar relationship to the urban area, both have a similar relationship to small settlements, both peripheral, and yet in one appeal one spends a vast amount of time, understandably because of the policy context, discussing accessibility issues, and in the other, very little. And in fact in the other it was accepted the site was accessible enough, mindful of its location, and mindful it was a peripheral greenfield site and that one could walk to various services and facilities, but it wasn't ideal, it wasn't town centre. So you have one appeal where sustainability is king, the other appeal it's barely touched upon. If one stands back and thinks about it, that's quite odd. Why should it be discernative in one instance and barely mentioned in the other? Or rather, why should we work in a system where policy identifies that that's essentially the determinative issue in one but not the other, when both have a clear need for additional housing? The converse is that in the Braintree site, one has a huge amount of discussion with regard to character and appearance and the existence of the gap. There was a conflict between landscape architects. There was discussion about the policy issue. One can understand why there was a lot of discussion. And yet in the other, in the Northampton case, there was very little discussion. Landscape really wasn't an issue, essentially because it was recognised that if one met the tests of the Joint Core Strategy and the Local Plan Policy SS1, that those other concerns would be outweighed, that those would fall away essentially. But again, it's odd that there is such emphasis on one in one case and less emphasis on the other. And I would note that one of the important issues in terms of this gap issue is the existence of the neighbourhood plan. Well, that's also slightly odd because in one you have the happenstance of a neighbourhood plan having been made, but you've got a very similar relationship between settlements and main conurbations, and yet in the other it's not even mentioned. In the Northampton case, maintenance of a gap was not really an issue at all. So the third point is perhaps the most important that I'd wish to stress, which is planning shouldn't be this complicated, and the approach to planning should not be dependent upon the happenstance of the existence of a neighbourhood plan, the happenstance of where a boundary is drawn, and the happenstance of the complexity of policy that seeks to get over the issue of boundaries. In reality, in both cases, there was an urgent need to increase housing to meet the needs of the conurbation. In both cases, one has development adjacent to the conurbation, and the question should have been whether the sustainability credentials of each site was sustainable enough, mindful of that context and mindful of how one meets that need with peripheral development. And in both cases, character and appearance should be consideration, and in both cases the relationship of a conurbation to the settlement should also be a consideration. In other words, the actual land use merits of any given development, particularly when they're in comparable locations or broadly comparable locations, shouldn't really be dependent upon the complexities of the system that we create, however well intentioned. So, two appeals, similar arguments in relation to each one might have thought, but actually very dissimilar main issues and very dissimilar outcomes. I was the advocate for both. Feels slightly hard done to in relation to one. but in any event, they operate as quite an interesting little case study. And certainly, if planning shouldn't be this complex, one has to think in terms of the current reforms about how we can make sure that determinations are based upon land use considerations rather than the happenstance of policy. Thank you very much for joining me. I hope that's been of interest. I'd like you to subscribe if you can to our YouTube channel, and we will be adding additional content as and when further interesting cases come forward. Thank you very much indeed.